Hello, everyone, and welcome. My name is Louis Brooks. I am a proud Brandeis alum from the class of 1980, a parent of a Brandeis graduate from the class of 2016. I am president of the Alumni Association, and apropos of this event, I was a judge on the 1979 to 1980 Brandeis Student Judiciary. On behalf of the Alumni Association and our co-sponsors, the Lawyers Alumni Network and the Legal Studies Department at Brandeis, it is my pleasure to welcome you to today's Alumni College program, The Future of the U.S. Supreme Court, Impact, Equality, and Justice. Today's marquee event features an esteemed panel of Brandeis alumni judges who will discuss equality under the law from the lower courts to the Supreme Court. The discussion will be moderated by Dan Breen, Associate Professor of the Practice in Legal Studies. We are delighted to welcome you, our alumni, Brandeis parents, Brandeis National Committee members, BALI members, and friends, both here on campus and those zooming in from around the world. I'm sure you'll agree, for those of you who are here in Spingold, how wonderful it is to be back on campus. I'd like to briefly introduce our panelists. Working across, the Honorable Sharon Goodie from the class of '85. Judge Goodie is an administrative law judge for the District of Columbia Office of Administrative Hearings. Next to Judge Goodie is the Honorable Joseph T. Carter from the Brandeis class of 1979. Judge Carter retired last month after serving more than 20 years as a Minnesota State District Court judge. Next, the Honorable Barbara Dortch Okara from the class of '71.
Oh, nice. Look at that.
Don't hold your applause till the end, please. Judge Dortch Okara is a retired Massachusetts Superior Court judge and a fellow university trustee. And fourth, and not least, the Honorable Melissa Crane from the Brandeis class of 1986. Judge Crane was elected to the New York State Supreme Court for the County of New York in November of 2020 and previously served as acting Supreme Court Justice and in the Criminal Court for New York County. Our virtual moderator for today's program is Alexandra Stevens, Assistant Vice President for Advancement Communications here at Brandeis. For those of you joining us online, please submit your questions for the panelists throughout the broadcast, and Alexandra will relay them during the Q&A. I will now hand this over to Professor Breen, who will begin today's program. Professor Breen.
Okay, thank you, Louis. Thank you for all you and Denise do for Brandeis, and thanks to all of you for all you do for Brandeis. Welcome, alumni. Welcome, alumni in person, and welcome, alumni remotely as well. So as you just heard, I'm the moderator for today's discussion, accompanied as I am by these four honorables to my right. And I'd just like to give a few introductory remarks, and then we'll turn things over to them for some brief remarks that they prepared for today's event. What an opportune time for a discussion like this. We are living at a time here in 2022 when 2/3 of all Americans in a recent poll were said to have very little faith at all in the Supreme Court's ability or tendency to follow the law in the Constitution rather than politics. Many people today believe the court to be a politicized institution through and through. And no less an authority than Justice Sotomayor, during the very heated and contentious hearing during the Dobbs case a few months ago, happened to echo these comments when she said during the oral argument, should the Dobbs case result in an overturning of Roe versus Wade, she wondered, should the court or can the court survive the stench, she said, that this would create in the public perception that the Constitution and its reading are just political acts. And I must say that the court itself is not doing that much these days to dispel the idea, at least, that it seems to be a very political institution and that decisions and voting patterns are influenced more by politics than law. Just one example I wanted to bring up before we get to our panelists is the fact that very recently a lower court panel of the federal courts down in Alabama happened to strike down an Alabama law that created voting district lines in violation of the Voting Rights Act. And according to that lower federal court panel, those lines diluted improperly under the Voting Rights Act minority voting strength. And I think, and most authorities do believe, that the law was squarely on behalf of that decision. But there was an emergency appeal from Alabama, from the state, and the Supreme Court, with very little explanation, decided to stay the effect of the order overturning those lines, so that as of the midterm elections, those lines, which seem to violate the Voting Rights Act, are still going to be in place. And it's this kind of thing that has people wondering about the future of the Supreme Court. Now, before I turn things over to our very distinguished panelists, I did want to point out that 3 of the 4 of them are serving jurists at the moment, which means that they'll be unable to comment, owing to judicial ethics, on recent impending Supreme Court cases, that is, specific cases. But they can talk about their experience as judges. They can talk about the rule of law, the importance of the rule of law, and they can certainly talk about issues of diversity and equity and justice that they've encountered during their distinguished careers. And I know I'm really looking forward to hearing what they have to say. Now, the way things are going to work in this discussion is they're going to go first, each one of them individually, presenting some prepared remarks. And then after they get done with that, there'll be a very informal discussion among the 5 of us, more or less a give and take. And then after that, maybe a little less than an hour into it, there'll be time for question and answer. So that will be to you in the audience. And at that time, you can come up and talk in the microphone. And our virtual audience will also get a chance to ask their questions as well. So let's get things rolling with our first discussant, and that is going to be Judge Dortch Okara. Right ahead.
All right. Good afternoon, fellow alums. I want to extend my thanks to my trustee colleague, Louis Brooks, to Professor Breen, to Allison Sakin, and all those who played a part in organizing this Alumni College event. Friends, we are in the midst of turbulent times. Since I am the only judge on this panel who is fully retired and free to speak openly about my views about the Supreme Court, I'm going to take advantage of that opportunity and speak frankly. I'm going to highlight 2 areas of the law in which the conservative majority on the U.S. Supreme Court is working to take us backward to the days when states' rights were sacrosanct. You may not agree with that statement, but I will attempt to make my case. I'll touch on a few additional cases that are waiting in the wings and that are likely to disappoint you. Let's start with Dobbs versus Jackson Women's Health Organization. That's on everybody's mind. Dobbs is the case brought by the only women's clinic in Mississippi that provides abortion services. It challenges the 2018 Mississippi statute that prohibits, with few exceptions, abortions after 15 weeks of gestation. The federal district court heard the case and granted an injunction prohibiting the state from enforcing the statute. The court applied Roe v. Wade. The district court ruled that there is no evidence that a fetus would be viable at 15 weeks and that prior case law controlled and prohibited the state from banning abortions prior to viability. Now, as we've all heard, the decision in Dobbs is due to be released by July. Of course, we already know the outcome of the case because the draft opinion of the majority was leaked. Now, Justice Alito's opinion doesn't simply reverse the district court decision. It eviscerates Roe and Casey, the subsequent case. Now, why does Alito go this far? This is what he says. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one which the defenders of Roe and Casey rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee that some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. Remember those terms. Now, according to Justice Alito, there is no right to privacy that is protected in the Constitution. And if there were such a right, it's not deeply rooted. And it is not implicit in the concept of ordered liberty. But how deeply rooted must a right to privacy be? Roe was decided in 1973. 2 generations ago. I was in law school then, in my early 20s. What other protections have we taken advantage of that are based on that right to privacy? Well, let's start with the precursor of Roe, Griswold versus Connecticut. This is the 1965 case that struck down a statute that criminalized the use of contraception. The Griswold court explained, while the Constitution does not explicitly protect a general right to privacy, the various guarantees within the Bill of Rights create penumbras or zones that establish a right to privacy. Together, the First, Third, Fourth, and Ninth Amendments create the right to privacy in marital relations. Now, if you are content to rely on Justice Alito to protect you if a state dared to bar contraceptives, then what about interracial marriage? The Constitution makes no mention of interracial marriage. The framers of the Constitution would have been outraged by that prospect. Has it been legal long enough that it has become deeply rooted in the nation's traditions? Well, Loving versus Virginia was decided June 12, 1967. That was 55 years ago that Virginia's Racial Integrity Act was struck down and interracial marriage became legal across the country. That was only 6 years before Roe. And what about same-sex marriage? In Obergefell versus Hodges, the court held that the Due Process Clause of the 14th Amendment guarantees the right to marry as one of the fundamental liberties it protects. But note that this case was decided in 2015 by a 5-4 majority in which Justice Alito dissented. I guess that right wasn't sufficiently deeply rooted. Alito writes in the Dobbs draft opinion that we've read that it is time to heed the Constitution and return the issue of abortion to the people's representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. By citizens trying to persuade one another and then voting. Does that mean that we cannot count on the Supreme Court to protect us from oppressive state laws? The third branch of government now wants to morph into a twig. Well, so be it. We'll have to take to the ballot box. But wait, can we vote? If we can vote without obstruction, will that vote count? That raises my second set of issues with this court, voting rights. You'll recall that the Supreme Court began retreating from the Voting Rights Act in 2013 in its decision in Shelby County versus Holder. There, the court nullified the provision of the Voting Rights Act that required pre-clearance from the federal government when a state or local government proposed changes in its voting laws that negatively impacted minorities. Fast forward to the Alabama case that Professor Breen spoke of, Milligan versus Merrill earlier this year. You've just heard that that's the case in which civil rights organizations filed suit on behalf of Alabama's Secretary of State, challenging the state's congressional redistricting plan. The plaintiffs in that case claimed that the plan is an unconstitutional gerrymander because race was the dominant consideration in drawing the new congressional districts, and that the plan was drawn specifically to dilute African American citizens' voting strength in violation of the Voting Rights Act. Well, of course, they sought a ruling to bar the use of that plan. And as you've heard, in January, the Federal District Court granted a preliminary injunction, finding that there was a substantial likelihood that the Voting Rights Act was violated, and because black voters were given less opportunity than white Alabamians to elect candidates of their choice. In February, after the appeal by the state of Alabama, the Supreme Court set aside the district court order and issued a new order allowing the state's tainted plan to be used in the upcoming 2022 election. Now, the court released no written opinion to justify that action. However, Justice Roberts stated that the district court properly applied the law. The district court was correct. However, some of the justices in the majority said, well, there wasn't enough time before the next election for a new plan to be drawn up. And the Supreme Court will hear the case on the merits during the next term. And then perhaps there'll be a new plan after the 2022 election. So the congressional plan did violate the rights of black Alabamians, but nevertheless, that same plan will be used for the 2022 election. Another example of the court's disrespect for voting rights is Brandesian versus the DNC, the Democratic National Committee. At issue there were two Arizona laws, one that banned the collection of absentee ballots by anyone other than a relative or caregiver, and the other threw out any ballots that were cast in the wrong precinct. Now, Arizona has permitted early voting for over 25 years. They're pretty expert at it. Now, despite that fact, there was no evidence of any fraud in the history of third-party ballot collection in the state. And despite that, the legislature enacted the law that criminalized the collection and delivery of another person's ballot. The DNC asserted that these practices violated the Voting Rights Act and the 15th Amendment. The DNC prevailed before the Ninth Circuit. The Ninth Circuit ruled that the laws had an unequal impact on minority voters and that there was no evidence of fraud that would have justified the use of those laws. Now, that ruling, of course, was reversed about a year ago, in last July, but in a 6-3 decision that was authored by who else but Justice Alito. He wrote that the unequal impact of these laws was there, but that impact was minor, and that states don't have to wait for fraud to occur before enacting laws to prevent fraud. Now, that decision has been criticized rightly as virtually gutting what remains of the Voting Rights Act. Now, what can we look forward to in the court's next term? Well, among the coming attractions in the area of civil rights are these cases: Students for Fair Admission versus Harvard. Now, there the plaintiffs allege discrimination against Asian American applicants in favor of white applicants. Harvard says it uses race as one of many factors in admission practices, but argued that its process adheres to the requirement outlined in Goodie versus Bollinger. Beyond the issue of whether Harvard's admissions process violated the Civil Rights Act of 1964 is the issue of whether colleges may use race at all as a factor in admissions. Now, judging from the way the Supreme Court rules in cases of this sort, it's unlikely that they will simply address the question of whether Harvard has acted correctly, but unfortunately, they may view this as an opportunity to abolish race, the use of race as any factor in admissions. So, will Bruder be overruled? That's the question. Another case to be mindful of is 303 Creative Llc versus Atlantis. This is a case in which a company challenges Colorado's Anti-Discrimination Act that prohibits businesses from discrimination on the basis of sexual orientation. This law bars the publication of any communication that says or implies an individual's patronage is unwelcome. The plaintiffs in this case is a graphic design firm that plans to expand its business to include wedding websites. However, the owner opposes same-sex marriage on religious grounds and does not want to design websites for same-sex weddings. They want to post a message on their own website explaining their reasons for objecting to same-sex marriages. Before the state sought to enforce its anti-discrimination laws, plaintiffs went into court and filed a case in the federal court. The federal district court, of course, granted summary judgment in favor of the state, upholding the Colorado law, and the Court of Appeals affirmed. Now, it'll be interesting to see what the Supreme Court does with this case next year. Will it rule in a way similar to the ruling in the wedding cake case? Some of you may remember the wedding cake case. Masterpiece Cake Shop versus Colorado Civil Rights Commission. In that case, the question addressed was the freedom of religious expression. This case takes a slightly different bent, although it is based somewhat on the freedom of religion. The case before the court now is asserting a freedom of speech in speaking on its website against patronage by same-sex couples. Well, we'll look forward to a decision there, but we're not hopeful. People, gone are the days when we could look to the Supreme Court for its support of civil rights and democratic institutions. Now, when the court rules on these issues, it appears to be just another player in the political arena. And that's pretty sad. Thank you.
Thank you.
Thank you.
And now we will hear from Judge Carter.
Good afternoon. My name is Joseph Carter, and I noticed when I was introduced earlier, there was no applause, so I'll tell you a little bit about. Originally, I am from Bedford-Stuyvesant, Brooklyn, New York. I came here to Brandeis and graduated in '79, so a very long time ago. After that, I went to grad school. I have a master's in social work from Barry University, and then I went to the University of Minnesota Law School. After law school, I practiced as a legal aid attorney. From there, I was a prosecutor for a short period of time, and then a public defender for a very long time. I was appointed to the bench in 2001 and served from then, February of 2001, until May 2nd of this year. So I'm getting used to the idea of being retired, although I do plan, as you heard, to go back and work as what we call a senior judge. In Minnesota, the court system is sort of modeled after the federal system. So our highest court is called the Minnesota Supreme Court, where we have 7 justices. and there's a Court of Appeals and a district court. Serving as a district court judge, I got to see just about everything. It is where cases begin. So if you are getting divorced, if you're planning to sue someone for money damages, if you have family law type issues, if you are a juvenile who has come into contact with the Juvenile Justice Center or system, and certainly people who are arrested for crimes, your cases start in district court. And so to some degree, I've seen a little bit of everything. And what I'd like to talk about briefly is the trust we have in our court system, and particularly for those who are people of color. We're now in an atmosphere or an environment where almost everyone has some distrust of our court system. As we heard just a moment ago, that it looks as if Roe v. Wade may be overturned. And a whole litany of cases coming from the United States Supreme Court on down, in which we have some issues with trust. However, given what we are looking at in this day and age, the Supreme Court has always been fairly political. That gives me a little hope that maybe things will continue to progress in our society. But if you recall, we've had President Taft, who became a Supreme Court justice. We had others who were governors and other politicians who have become Supreme Court justices. We've had a Supreme Court justice who had direct telephone lines to the president, advising the president, in particular Lyndon Johnson back in the day, where Judge Fortas gave him lots of advice on how to conduct the executive branch when he was on the Supreme Court. And so hopefully that gives us a little sense that maybe the sky isn't going to fall on us. But from my standpoint as a district court judge in the state of Minnesota, one of the things that I've observed, and I'll give you a brief example, when I've conducted traffic court hearings, the scenario typically is like what we see in this room. Maybe 100 people, all of you are charged with a minor traffic offense, for example, speeding, going through a stop sign, driving without a valid license. And where I sit in the state of Minnesota, in Dakota County, the demographics of the population is about, probably about 30% people of color. And as each case is called, everyone sitting, waiting to have his or her case come before me is able to see and hear the process and able to see what happened to the prior person. Typically, the scenario is people will talk to the prosecutor, see if they can work out a deal. Most people in that scenario are trying to work out a deal where their record will not, or their offense will not be certified to their record, so that they'll have a clean driver's record that will certainly affect insurance, all of those things. And unfortunately, even with my being there, a black judge, most people of color have a tough time trusting the system. They have a tough time, even after watching other people plead guilty to an agreement with the prosecutor that, for example, the case will not be certified. They have a difficult time doing it because pleading guilty is something that is very troubling. And so we must ask ourselves, why? Why? And ultimately, they come out for the worse because they'll either try their case or they will have to come back to court a second time. That takes time off work, all sorts of things that are not helpful to them, and then end up typically with a conviction. And had they taken the deal, as I view it, that probably would not have happened. But that's a result of what the community has experienced. And the trust in the system is something that really affects them, in which even as a judge, someone of color, it's difficult for me to do because it's not my role. But just think about some of our history. In 1956, for example, there was the war on crime. We had 3 strike laws, 0 tolerance. And so if you're a person of color, you know someone who was caught up in that net, and that creates the distrust of the system. When we hear about prosecutors, for example, there's always a get tough on crime, and you've never heard a prosecutor advertise herself as, I'm going to be lenient, or I will be fair and just. And we just, in the news now, have a prosecutor from San Francisco who has lost a recall election because he had taken that approach. And finally, to wrap up my comments, we also have some judges in Minnesota. At one point in the early 90s, we had a group of judges who referred to themselves as the crack cocaine judges. And what they did was, and they saw themselves as, I think, helping the Black community, but they saw themselves as sort of cleaning up that community with drug cases. And what they did was to form a sort of a party among themselves, and this committee of judges consisted of probably about 4 or 5 judges out of 19. And what they did was they passed the cocaine cases among themselves and handed down draconian type sentences for minor offenses of possessing cocaine. In this day and age now, that we can't imagine that happening, and now a whole view of how drugs are handled. And I think some people would say, and that's because drugs have now infiltrated our entire society. There's now this concept of, well, let's help these people and not be so draconian. Thank you.
Yeah, thank you. Thank you. Now, Judge Goodie.
Hi, everybody. I'd like to talk about 3 separate categories. The first one, I want to explain what my court does. And then I want to talk a little bit more. Judge Carter gave me some great segues into racial justice, justice involving people living in poverty. And then I'd like to add some hopeful things at the end about things that hopefully everybody in this room can do to help make the legal system a little more welcoming to the folks who need it most, folks who are living in poverty. Let me first start with what we do. So I think all the lawyers in the crowd will know an administrative law judge is usually hired by the agency for which that person hears cases. So if you've got a problem with your Social Security, you go to the Social Security office, you talk to a judge who's paid by the Social Security office, and maybe there's some bias there. The person is being paid by the agency that you disagree with. So in a number of places, not just Washington, D.C., but in most urban areas in the country, they've started something called a central panel, where they take those administrative law judges out of the agencies and they put us together in one independent court, and that's where I work. And there's one here in Boston, there's at least two in California, there's one in San Francisco and one in Los Angeles, one in Chicago, where I came from, and they have talked for a while about making a federal central panel, but it hasn't moved forward on that. And I can see why there's so many thousands of administrative law judges in the federal system. But anyway, back to what I do. So my court hears cases from 50 different DC agencies and growing. There's actually a part of our enabling statute that lets agencies who need a judge to make decisions on a category of cases, we can actually set up a memorandum of understanding, which is government speak for a contract. So we can hear those cases. And what's happened in a number of agencies, they've said, okay, Office of Administrative Hearings, we like what you did with these cases, we're gonna expand, why don't you take all our cases? So right now, I hear cases about Medicaid, about food stamps, which is now called SNAP, cash assistance, disability assistance, homeless shelters, because you can be kicked out of a homeless shelter, and I'm sure that's true in all jurisdictions. Nursing homes, you can be kicked out of a nursing home, you have a right of appeal with us. School discipline cases, there's an automatic right of appeal if your kid is suspended or expelled. Property cases, not everybody knows if you don't contain your trash properly, you can get a ticket from your jurisdiction. You can appeal those to my court. So it's taxi cab cases, et cetera, unemployment insurance, rental housing conditions. So I get to hear a lot of very interesting cases. They kind of, they refer to us as the people's court. I'm using air quotes here because it's where a lot of people interact with the judicial system, even though we're part of the executive branch, not the judicial branch. So that's what we do. The hope is that we're not biased and we're not seen as biased, because all judicial ethics codes require that we look for the appearance of impropriety as well as actual impropriety. We're supposed to avoid both. In many cases, local agencies, their judges aren't actually lawyers. So when they put us together, they require that everybody be a lawyer who's an administrative law judge. So we're trying to sort of make us look more legit. And so that's what we do, and it's a fascinating job, and I'm really lucky to have it. I want to talk a bit about the other hat that I wear. I'm on the local DC Access to Justice Commission. Access to Justice Commissions you will also find in most urban centers, and I'm hoping also in suburban and rural centers as well. We work on making it easier for people who cannot afford counsel, which is mostly everybody. Counsel is very expensive these days. We try and make courts more accessible and figure out how we can do that. And so I've learned some grim statistics to follow up on what Judge Carter was talking about. I'm not actually going to give you statistics. I'll talk about trends. There are studies that will talk about how black and brown people in the criminal justice system are getting longer sentences for the same offenses as white people. We're hoping to work on that. There's also the converse of that is that a lot of people who are victims of crime, for the reasons that Judge Carter talked about, are afraid to talk to the police about it. Now, some of that is the snitches get stitches, which is real, especially in a gun-laden culture such as ours. But there's another piece to it. There are people who are really afraid that the police and the judges are together, and by talking about what happened to you, the bad thing that happened to you, you're going to be seen as a criminal. So when you hear about all the cold cases, especially homicides and serious assaults, there's a real fear in the community of talking to police, of telling your story if you're a crime victim, because you're afraid you're going to somehow be associated with having done something bad yourself. And that's just on the criminal side. I also see myself on the civil and administrative side when I hear the Medicaid cases. And I can only speak to what I see in the District of Columbia, but I suspect it's true in other urban areas. The vast, vast majority of people I see on poverty benefits such as Medicaid and food stamps are black and brown. I rarely see any white people in my courtroom. And so poverty has this thing that makes everything so much harder, makes racial justice so much harder. And in the school discipline cases, there are also studies that are showing that in public school systems, black and brown kids are suspended more frequently and they get longer suspensions than white kids with similar offenses. Same problem, just on the civil side. And you may have heard, or this may be new, about the school to prison pipeline philosophy that's going forward. Kids are getting kicked out or suspended, which never made sense to me. If your kid isn't staying in, is having a hard time in school, you kick them out. Isn't that giving them a present in some way? But anyway, they get kicked out of school. They don't go back. They don't have skills. They're not learning the skills they need to get even low wage jobs. So crime is one of the only ways that they can actually make money. And so people are trying to work on that. How do we get out of that school to prison pipeline, and how do we do a better job by our kids? The other thing I see, we don't deal with IDEA cases, which is about the right for kids who have disabilities have a right to have services provided by the public school system to give them an equivalent educational experience in the public schools. A lot of the public schools aren't following the law on that. There's a large class action suit still going on in the District of Columbia because DC schools are not giving kids with special needs the services that they need, or the only way they can do it, which is a killer for our budget. They're sending them out of state to residential schools, but then when they come back, they're giving them no skills to handle the poverty-stricken neighborhoods that they go back to. So it's a tough thing. And we aren't giving these kids a chance to get ahead and starting so young. So there's all the really sad, awful stuff. I want to, in my third part, talk about hopeful things that we can all do. Certainly, I know that a lot of people who went to Brandeis went to law school too. So I'm going to encourage everybody, please consider, if you're retired, if you're semi-retired, if you're still practicing, consider pro bono service. For those of you who don't want to be in the courtroom, I don't blame you. It's very stressful being in the courtroom. I'm a former prosecutor, and it was an adrenaline rush, but it was also very stressful. We've got stuff for you to do too. At any trial courthouse, we need people to help people navigate. We actually now have a name for it. We call it navigators. If you walk into a large urban courtroom, you don't necessarily know where to go, and there's a long line to talk to the information people. There are navigators who will show you which courtroom to go to. There are people who are drafting booklets, because those of us who are lawyers know when we go to law school, we're taught not to speak English. We're taught to speak in really long sentences with really long words that make us impossible to understand. We as judges are being trained, and I can't speak for my colleagues, but I'm guessing, on writing and speaking in plain English so that we can be more relatable to people who don't speak legal. We're also, let me come back to that other topic in a moment. So we're being trained on that. We could use help from lawyers who can translate legal into English to explain in written form people who can't afford lawyers to put explanations about what they can do to put on their own case. We can certainly use people from other professions who can be helpful too. One of the things that we're experimenting with in the district is co-locating. So I'm going to talk for a moment to the folks who are in the health professions. We've got a lot of lawyers who are co-locating in medical clinics to talk to people about, okay, it looks like you're struggling with health. Have you applied for Medicaid? If so, did you get Medicaid? Because I'm taking a look at your income information and you may be eligible. If you didn't, did you know about the Office of Administrative Hearing? They can help you if you should have those Medicaid benefits and you don't, and you haven't gotten them. And we've been seeing that there are a lot of places where people who are entitled to some of those poverty benefits either haven't applied for them or who have applied and they've been denied, but they haven't done anything about it because they didn't know they could. One of the biggest studies my Access to Justice Commission did was to talk to folks living in the areas with the most poverty about what they thought was a legal problem. And a lot of folks don't even know that if you don't get Medicaid, it's a legal problem that can be resolved in a courthouse. A lot of folks don't know if they don't get their food stamps, it's a legal problem, and you can go talk to a judge about it, and chances are, if you're legally entitled to those food stamps, the judge can make it happen. And it's real. It's fun when I can look at the agency that deals with food stamps and say, hey, you guys messed this up. I need you to fix this today. I've already given you 2 weeks. I've already given you a month. Fix this today. Or we're coming back tomorrow. I want to see that it's fixed. That's the best part of my job. And sadly, the agencies are underfunded, understaffed, overstressed. They work as hard as they can, but they're getting a lot of things wrong. So anyway, we need people in the medical professions to co-locate with those lawyers so that their clients who need help in other areas can get help on the legal problems that these folks have. For those of you who are in the business community or who do finance, legal aid and other legal service providers, they are struggling too, especially in the previous administration. I'm not supposed to talk about politics, but in the previous administration, so many dollars are stripped from legal aid and other organizations like that. that a lot of their lawyers aren't in court. A lot of their lawyers are working on getting grant funding so that they can pay themselves, so that they can keep going. And we're not talking about big salaries for legal aid attorneys. So those of you who are in business or finance, if you want to volunteer to help with grant writing for a legal aid organization, they would love that. That way they can put more lawyers in court, more boots on the ground. So I think I've hit all the major professions. I want to encourage everybody to volunteer. Ask me questions. I can only, of course, talk about Washington, D.C., but I think there's a lot of analogs in other urban centers, and I hope that the analogs are reaching out to rural places, because poverty is just as difficult in rural places as it is in urban centers. It just has different dynamics to it. So I'm going to stop there and encourage everybody to volunteer.
Well, thank you very much. Okay, and finally, Justice Crane will talk.
Hi, everybody. It's great to be here, and thank you. You can't hear me? Oh, sorry. I was just saying it's great to be here, and I actually started out here as a music major and was in Music 9060 for voice. So I will try projecting. Is that better? See, I did learn something. Actually, I ended up dropping out of the music program because I sucked. Compared to the other kids in the group with people with perfect pitch, I just couldn't compete and ended up doing other things. But I did want to thank Allison for organizing this. And your hospitality, and Dan for moderating. And you know, while we're on the subject of Brandeis, someone came up to me, so I've been a judge for 9.5 years, and you have to get elected for the most part in New York. There's some appointed positions, but I took the elected route. And so I was elected to civil court in 2012 and elected to Supreme, because New York does everything backwards. Supreme Court's actually the trial level court, in 2020. And when I was campaigning, someone asked me, why would you, as a privileged person, have given up, you know, a whole lot of money working, you know, I have a background in commercial law, and to do something that's high stress, very high profile, and low pay? And I said, I thought for a minute, I couldn't put my finger on it, and I'm like, I think it was Brandeis. I really do. You know, just the commitment to justice, you know, evening the playing field and restoring amends. So I really think that's why I did what I did. So thank you, Brandeis. Anyway, I want to talk to you today about access to justice and the digital divide, because it's very current. So as I said, I'm a commercial division judge. Well, my background's commercial. I sit in the commercial division of New York County, which is Manhattan, the financial center for the country. And we have highly moneyed cases. The jurisdictional threshold is $500,000, so you can't even get into the commercial division unless your damages are that high. And when the pandemic hit, it transformed our court. We went to a virtual court in under 6 weeks. We never stopped. The virtual proceedings have exceeded my wildest expectations. There was an initial concern that, let's say in a bench trial, I would not be able to assess credibility over the internet. But as a matter of fact, it's better, because in the courtroom, the witness is to my left. I'm looking at the audience. We've got a full courtroom. I'm being interrupted by 20 different people at all times, and then I have this personal thing where I'm always thinking I'm burdening people. So I would think, oh my God, I'm taking too long, and the people in the back, they've been here for an hour, and you know, and it made me very nervous. So the virtual proceedings are great because nobody's waiting, everybody's in their office, and I can hit spotlight on the witness, and I'm catching tells I never would have seen. And so it's been, you know, I'm not sure the lawyers are not happy about this, but for me, it's great. So it's been a roaring success on the commercial side. It's great for the women lawyers. I've seen some people who are appearing in front of me, they're actually home. They don't have to worry about childcare as much. I think people are more relaxed, saving money for the clients. They don't have to come in. But at the same time, you know, in one day, I could have a case. I actually I became a commercial division judge a year ago, so I still have cases from my old, less moneyed part. And we had association of musicians, actually, in Harlem, and they couldn't, we were all virtual at the time, and you need 3 things to participate in remotely. You need the equipment, the devices, you need access to the internet, and you need the know-how. And these, particular people had the know-how. They were, educated very well. They knew how to get on, but they didn't have the broadband access. We're in their neighborhood. And it really didn't work. And I ended up taking the motion on submission, which isn't fair. It's literally their access to me was less. And there are, we're all very aware of it. The state court system in New York is definitely making inroads into lessening this digital divide, but it's a stark contrast, and it's not fair, and we need to do something about it. I mean, as another plus, though, I had COVID in January, and I did an entire virtual trial from my house. So, there's so many upsides to once people have access. It's great. You can get legal help virtually. Let's say somebody needs to appear in court and they have a job that they don't have to take the day off anymore. They don't lose that money. They don't have to worry about childcare as much. There's so many pluses. But if you don't have that broadband access, and it's definitely different, I know there's an infrastructure bill in Congress that should be trying to ameliorate that. I hope it works, but it needs to be even. And that's what I wanted to just raise awareness about.
Okay, thank you. All right. So in a little while, we'll get to the question and answer, when you'll all have a chance perhaps to come to the microphone. I'll let you know when that time comes. And also there'll be some questions virtually as well. But I did want to get a chance to ask a couple of questions from our panel. How often do you get 4 judges on the same stage? And one question I think may be on all of our minds, and that is the most serious breach of confidentiality in the history of the Supreme Court, which just happened a few weeks ago. And since you're all jurists, how did that make you react? The idea of confidentiality, how important that is, and what were you thinking when you read that news? And any of you can go ahead.
I was astounded because regardless of what the decision said or what the circumstances were, it's hard being an appellate judge. It's hard creating consensus. I haven't sat as an appellate judge, but I know several appellate judges, and there is a feeling of confidence in the confidentiality of your conferences about cases. It's when cases, a conference that positions are laid out. So when this draft was leaked, it had the effect essentially of deciding the case at that point in time, when in the normal course of events, drafts are traded back and forth maybe for months, even sometimes for years or many months before a final decision is made. It may be that even some of the votes can shift. But once a document like, Alita's decision was leaked, it hardened. I mean, if we had any thought that anybody would change their mind, that's out of the window. No one wants to feel that they've been pushed, that they are weak. So, if they had any doubts, I think those doubts are gone by now, and we will potentially suffer for that. So it's really, in my mind, a bad thing, regardless of what the decision says.
It makes me worry because when I'm working with the clerk, and I share a clerk with a few other judges, but when I'm working with the clerk, they know that I haven't made my decision until my final order goes out. And so and I don't want to say bad things about the clerks, because who knows where that leak was. But everybody I work with knows until I've signed it or e-signed it's not my final decision. So that makes me worried. The other thing I need to bring up is what scares me more is the guy outside of Justice Kavanaugh's house who wanted to kill him. And as we were saying before we went on, we could talk about judicial security just as a panel discussion on its panel topic on its own. Very scary. Whether you agree or not with Justice Kavanaugh, we have to feel safe in our physical bodies doing our work. And if something's going to get leaked out that isn't even my final decision and could put me at physical risk, that's a real problem.
Yeah.
And I'd also like to bring up maybe a few more general questions while we have you all here. And one question I think I've always been curious about teaching my students in telling them about law the way I understand it, maybe a question many of you are interested in, is what happens, and this must be very common for you, what happens when you get a case and maybe sentimentally you may favor one side or the other, you may wish you could rule for them, but you know maybe there's a really good reason why you can't. And I wonder if there's a way you could talk about that moment, which is in many ways unique to the enterprise of judging, and it's so seldom that we get a chance to talk to jurists about that. But you don't need to give an example of it perhaps, but did you experience that tension, and how do you think of it?
It's a tension that we, I think, deal with all the time. You go into a case, you've read the briefs, you certainly come to the hearing with an idea of what the outcome should be. And sometimes I change my mind as I start to write a draft of my order. And often, as a jurist, I'm wishing that one person or one side or the other had argued something that would give me the ability to rule in a way that I think justice would prevail. And I can tell you sometimes the law can be a dark hole. And sometimes we have to struggle to get out of that hole. And many times there's nothing we can do. As judges, we are mandated to follow the law. And we can sometimes manipulate the facts a little bit if we are given a chance by the litigants to do so. Because it's the facts, the rationale, and the law that we are trying to work through.
And if you'd like to add anything to that?
Well, just sometimes applying the law is really hard, and it can conflict with your personal beliefs. Like, I may personally believe the subway should be free, but when I sat in criminal court, I would, often take pleas on people who had jumped the turnstile, because that is, a crime in New York. And it's hard. It's really hard. I don't have to put them in jail, but it's hard.
It's hard with mandatory sentencing too, especially, when you have someone before you on, say, a gun case where there's a mandatory minimum of a year for carrying a firearm under certain circumstances in Massachusetts, and you see someone without a record, you see a young person, a person with promise, and a year to serve, this isn't a year probation or whatever, or suspended sentence, a year to serve is going to set that person back potentially for life. And it's hard. It's hard to do. You have to apply the law. Sometimes there are opportunities to get a prosecutor to reduce the case to a lesser crime. But sometimes you can't do that. You have to apply the law.
I want to pick up on that and talk about what happens when you put somebody in prison. Nothing. There's no rehabilitation in prison. Occasionally, I was lucky, I went to Georgetown Law School, and there's a clinic where we went and taught at when DC's prisoners were housed around DC. Our prisoners are now in federal system all over the country. And there are a lot of illiterate folks who are in prison. They go in illiterate, they come out illiterate. They go in with no job skills, they come out with no job skills. So one other place to consider volunteering, to pick up on that theme, and then I will come back to your question, I promise. Think about volunteering in your local jail or prison. For instance, if any of you who have dogs who are therapy dogs, they make a huge impact. They're doing wonderful things with prisoners who actually want to work with the dogs, and rehabilitation happens there to a big extent. If you want to teach literacy, it's so hard for folks who appear before any of us, I think, to acknowledge that they're either limited literacy or illiterate. Go teach somebody to read. Lots of volunteer opportunities. So back to your question, when somebody lies to me, and I agree, credibility is not about being able to see, it's about being able to hear, and being able to hear about somebody who can't keep a story straight. If they're going to be inconsistent, and that's where credibility lies. If somebody's lying to me, but they don't have the burden of proof, and the party with the burden is doing a bad job putting on their case, then I have to let the liar win, and that drives me crazy. Fortunately, it doesn't happen very much. Very few people are good liars, but every once in a while I have to rule for the liar as much as I don't want to do that.
Mm-hmm. Well, that brings up another question that both of you have raised, and that's the importance of the quality of legal representation in what you do, the arguments that are made. So much depends upon what the lawyers say to allow you the materials for the kind of decision you might like to make. So maybe with that as a theme, what would you change if you could change anything at all? What would you do to legal education if you could change anything about law school and how lawyers are trained? Is there something you might like to bring up now that you could talk about to suggest?
Well, typically, lawyers are trained to look at the law and apply it to a broader situation or other situations, and we call it the Socratic method in law school, where that goes on. And I went to a school where that was used extensively. And I would like to see in law school more clinics, and law schools have moved that way to some degree, but more hands-on where lawyers or students are learning to deal with particular cases and sort of apply real life or work with real life situations a little bit more than the theory that I learned when I was in law school.
Yeah. I think that's happening now. I taught as a law professor immediately after retiring for about 5 years, and that's the norm now in most schools. Some schools have cooperative educational programs built into the curriculum, but others are moving in that direction, requiring students to have a certain amount of clinical or experience or internship experience, actually practicing law or doing the work, legal work, beside a practicing lawyer before they graduate. And it's important for them to see exactly, to apply the law that they're learning. So I think more of that is for the better.
Mm-hmm. Well, thank you. And I think we're about time for question and answer. If members of our audience would like to come to either that microphone there or this microphone over here to my left, to ask a question, you're welcome to do so now. We'll also entertain virtual questions. We have a Zoom coordinator up there who's in charge of that. Just keep in mind that 3 of our 4 panelists can't talk about pending or very recent Supreme Court cases. But to the extent that you have a question that you'd like to ask them, feel free to walk up to the microphone now to do so. And in the meantime, while you're thinking about that, we have a question right here. So, and there's the microphone right in front of you. Go right ahead.
Is this on?
Let's see.
Yeah, it's on.
Is it on? Should I? Probably better without my mask.
Yeah, we can hear you that way. That's good.
I don't know how many of you can reply to this, but 2 questions related in terms of people talking about reforming the court, increasing the numbers, and or making it not a life position for the Supremes. Any comments, opinions on either of them?
Yes, on
Is
reforming.
that clear?
I didn't hear.
I didn't hear all the question.
Well,
Oh,
you're
maybe
asking about
this isn't on.
reforming
Maybe there's-
the court
Reforming
in
the
the way it's
Supreme
chosen.
The Supreme Court?
Reforming
Yeah.
the Supreme Court.
Do we
I
want to
don't-
keep lifetime tenure or not? Is that the,
Yeah, is that better? There we go. In terms of increasing the number on the court, because it doesn't say in the Constitution how many, and or to change life tenure to a certain number of years. Any opinions on either of those ideas that have been tossed around a lot? Thank you.
I can begin. Increasing the number of justices on the Supreme Court, I question whether that's a good idea, because I can envision one president coming in and saying, okay, I'm going to increase it to 12 members. The next president says, oh boy, 8 out of those 12 I'm opposed to their views, so I'm going to increase it to 15 before we know it. We have 1,000 justices. And so I don't know if that's the way to go. I know some people have kicked around the idea of having a staggered court, for example, where a president ideally gets to pick 3 justices, the next president 3, and so forth. And with term limits, I've heard the number 18 years being kicked around a little bit. But I think life tenure is probably the better system than one that we have. And by the way, when the Supreme Court was first formed, as I recall, there were only 6 justices with 1 chief judge, and it was moved to 9, I think in the mid-1800s. But I think the better thing for us to have is, for example, where the justices don't completely police themselves. So there are times, I think, when there is a conflict of interest, and so we need some type of law statute that prevents a justice from hearing a case that he or she, there's certainly the appearance of a conflict. That's very important. So I think there's some things that could be done in that light versus increasing the number of justices or term limits. Those are my thoughts.
yeah, it's a remarkable thing that the Supreme Court, almost alone among institutions in the United States, has nothing like an ethics code. It's a remarkable thing.
Yeah.
Would any of you like to comment on that question? before we move on?
Well, I think I would not, for the same reasons Judge Carter mentioned, I wouldn't want to see the number continually increased. But I do think there's a need for mandatory retirement. Most states do have an age in which judges are forced to retire. In Massachusetts, it's age 70. In many states, it's 70, some 75. Whatever the age is, I think there needs to be opportunity for the court to get new blood, and not simply by death or illness and the like, and something that you can look forward to particular vacancies at given points of time.
Well, on that note, while some of you are gathering your courage to walk up to the microphone, oh, here's one person here. Go right ahead.
Hi, is that on? Yeah.
Yep, I think we can hear you.
I really enjoyed hearing all of your points of view and I really enjoyed listening to your discussion. It was really very interesting to me. I don't get an opportunity to speak to 4 judges very frequently. My question is not exactly germane to any subject particularly carried right now. I just came in from California. A couple of days ago, we had an election. There were 21 items on the election where I am in Southern California. 9 of them were voting on judges, okay? Nobody knows who these judges are. I try to be a responsible voter. I have trouble getting information, hearing opinions, that sort of thing. It takes enormous research, whatever. I'd just like to hear your opinions on that, whether we should be voting for judges, the average person in the city, or if you have another method of doing it and what your opinions might be. Thank you.
And I think 2 of you were voted. at one time or another, right? So,
Not me.
yeah. So if you'd like to talk about the advantages of that, or how you feel about that, or if you feel uncomfortable about that, that's okay too. But if any of you have any thoughts on that,
Yeah.
go right ahead.
I'm against electing judges. And of course, I'm biased because in Massachusetts, judges are not elected. They're appointed, like in the federal system, for life, essentially until mandatory retirement. But on good behavior, there is a Judicial Conduct Commission that's very active in policing behavior of judges. So you can be removed. But I just don't know what it would be like to run for office. And some of you can tell us.
I'm in a jurisdiction where it's a little bit of a hybrid. So under our Constitution, the judges are elected, and that's the case in most states. And so what happens is, for example, I retired a few weeks ago, and I retired in the middle of my 6-year term, and as a result of that, the governor appoints my replacement. And typically, in most states, as in Minnesota, there's a commission on judicial selection, and it's made up of a couple of judges, several lawyers. They interview people and make a recommendation to the governor on who should be appointed. And typically, almost always, the governor appoints that person who goes through that selection process. Once that governor appoints the judge to the bench, then that judge has to run for election between 1 and 3 years, depending on the cycle of the election period. Once that judge has been elected by the public, then he or she is in the office for 6 years until he or she retires. They retire on May 2nd, like I did, then the governor gets to do the process again. I have a lot of reservations about judges being appointed, and I think of the civil rights era, where judges had to decide whether or not blacks had to be compelled to ride in the back of the bus, could be served at restaurants. Those were federal district court judges who made those tough decisions. And that's because, and they were able to make those decisions because they were not elected. If you know anything about the Scottsboro boys in Alabama, I believe, that judge, that case is, there was a novel by Lee Harper that sort of followed that case, To Kill a Mockingbird. And the judge, who, at one point, a district court judge or a trial judge believed that one of those boys did not commit that rape and gave him leniency. The following year, he was voted out because there was a lynch mob who wanted to have those 12 or 10 or 9 kids, I think, executed. So when you're making decisions, thinking about whether you will be able to keep your job, that's not a good thing.
Well, in New York, we have a type of hybrid system. So I'm elected. Some judges are appointed, the criminal court judges are appointed by the mayor. Court of Claims is appointed by the governor. And so there's, there's good and bad aspects to all types of ways of becoming a judge. But I think your question was more, how do you find out about these judges?
Well, that is a question.
Yeah, so we see, I don't know if,
Judges for the 9 courts, 4 judges in each category, 36 people.
Yeah.
so I know with New York, it at least downstate, so I can't really, upstate's different. So I'm only talking about really New York City, but it's very blue, so the Democratic Party really controls the elected process because the Republicans cannot win. And, well, I, at least for the most part, I mean, there's Staten Island that I don't know if there are primaries there. It's really kind of messy to specify New York City because it's different. But let's talk about Manhattan because that's what I know. So it's really, there's deep vetting that goes on both sides, actually. So the appointed process and the elected process, there's a tremendous amount of vetting, and I know because it's exhausting. There's panel after panel, both on the appointed route and the elected route. The Democratic Screening Committee puts together the elected screening panels, and I don't know specifically the appointed route because I didn't go that way, but they have their own screening panels. So by the time we get on the ballot, there's been an enormous amount of vetting. I imagine it's similar in Southern California because of the politics, but so by the time, were you voting as a primary? Like, were there two people against each other, or?
The judges, I don't believe
It was not, right. So that's the same that we have because the whole process is, a lot of it's on the internet also. I think people who wanted to see about me could by the time I was running for Supreme, I'd already been a judge for 7 or 8 years, so you could look up my decisions, obviously. But I think there is a certain amount of not knowing where to look for the general public, and I think you raise a very valid point about, how do we educate the electorate about the judges in general, because otherwise you're just relying on the screening folks.
Can I touch on?
No, go ahead.
Oh, sorry.
No.
Okay. I do know that in some states, and I know in Chicago, bar associations will vet people who are running for election and give their recommendations. Now, Chicago is as deep blue as Manhattan is, but downstate, totally different again. And that can be helpful if you know where to find it. Sometimes it'll be on a website. Sometimes a Chicago Council of Lawyers used to publish it, I think, in a newspaper. I know this because my mother served on the Chicago Council of Lawyers. She went to Brandeis, too, and a retired judge. So look for a bar association that might be able to give you some information. I'm an appointed judge, and there are issues with that too, because part of the reason I got this job is because there's a 5-member statutory commission. The head of that commission used to be my boss when I was a prosecutor, and I helped with a high-profile case and made the city look good. So he was like, "Oh, Sharon, yeah." And he also had seen my work because it was a high-profile case. I was reporting to him. But so it is about who you know, and that sometimes can be positive, but sometimes it can be negative too. So I think there's flaws going both ways, which may be why there are hybrids, just a guess.
And also, the bench needs to reflect the population of the communities it's judging. I think that's a concept that I believe. And so how you get to that point and the diversity you need is really, really important. And no matter how that works, either appointment or elected, that's really should be the goal, or one of the goals.
And I think we have about 10 minutes or so to go to virtual questions. So probably there are some from the remote audience.
Yes, thank you, Professor Breen. Lots of discussion online. I think everyone's hungry to hear your thoughts on some of our most recent headlines. We've had several questions about the current Ginny Thomas headlines, so I'm not sure if any of the panelists can speak to that. Wife of Clarence Thomas, and pressing lawmakers to reverse Trump's defeat. And a specific question, is there a way to prevent Justice Thomas from ruling in a case involving his wife and potentially even himself?
So I'm not sure if that's one that all of you can comment on.
Well, I think the short answer is no, and that's problematic, that the Supreme Court is not bound by any code of ethics. All the lower courts, federal, and I'm sure in state jurisdictions, there are codes that judges follow, but the Supreme Court is not bound and cannot be disciplined or brought to heel for anything that we view as violations. I mean, they can decide amongst themselves, certainly, but nothing can be imposed upon them, and we won't hear about anything that's done internally unless they publish it.
Are there?
Yes, other questions. So from one of our listeners, we happily reversed Plessy versus Ferguson, even though it was on the books for a long time. This is the case that set up separate but equal. This may be the same for Roe v. Wade, but time is not the deciding factor, is it? And related to that, if Roe v. Wade is overturned, when and how could we pursue restoring that?
When and how, what?
Yeah,
Pursue restoring.
Restore Roe.
Yeah, restoring Roe might be a trick if it's actually overturned. And I think, as we heard earlier, you have to go to the legislative process for that. But the entire idea of precedent was at stake in that draft opinion in Dobbs. And this might be a good time maybe to talk about how you perceive precedent. How actively do you perceive that as binding on you? And what's the importance of precedent in what you do?
Well, as a trial court judge, that's not an issue because I have to follow the law. For the Supreme Court, they get to interpret and to some degree make the law. And so they ideally, I think, find themselves thinking about precedent. Sometimes it can be a bad thing. I mean, we've had some cases where we're all glad that those decisions were overturned, but on my level, and I assume most of us here, that's not an issue for us.
There's the difference too. We're all bound by ethics codes. We all are required to follow stare decisis. It's wholly different there. And I forgot to mention, Dad went to Brandeis too. Hi, Dad. And he's watching.
So speaking of ethics codes, how do you all as judges leave your bias at the door of your courtroom? You started talking about that briefly.
Constant vigilance.
Yeah.
I'm sorry, I didn't hear you.
Constant vigilance. You have to always check yourself. You know, everyone comes to the table with their own background and their own experiences, and you have to set that aside and judge the case on the facts and the law before you. It's very, very important. And, you know, on the subject of training lawyers, I really think the implicit bias training would be an important class for law school. There wasn't that when I was in law school. I don't know if that's changed.
And there are classes and various programs amongst judges. Many of the courts have judicial education programs that emphasize issues around implicit bias. But it's a day-to-day thing. You can't walk in and say, I've arrived, I will not be biased against anything or for anything. It's a struggle every day. But you owe that to litigants. You're not there to pursue your own ends. So it can be difficult. But it's important that there is diversity on the bench, that we come there with our own backgrounds, our own affinities, our own views about things. You really do have to reflect the populace before you. But, you know, in an individual case, you've got to toe the line and call it as you see it and as the law requires.
And we also have to be working on temperament, and temperament and implicit bias frequently go hand in hand. So we have mandatory training on both of those things, and those are not easy things to train on. And we have to, I see it as I'm a work in progress. And, I'm never going to be totally right, but I try to improve myself as much as I can.
And I think that's an important thing for students these days to hear, I think, that there can be such a thing as the rule of law, but the rule of law is consistent with your own backgrounds being important in shaping how you view some of the issues that come before. And that's another reason why, as we just heard, diversity in these institutions is pretty important. And I think you have another question, maybe?
Yes, we do. So speaking of diversity or lack of diversity, with the Supreme Court conservative majority, how are you viewing the future of this court and the cases that it will be taking in the coming years?
I'm having a little trouble hearing what the entire question is.
Yeah, the question may be one to which at least one of us can respond, and that would be, how do you see or view the future of the Supreme Court, especially in coming years?
Well, I'll just say that I think it is quite a bit grim, at least on the issues that are important to me. Now, there are lots of issues relating to business and the like that are ruled on as a matter of course that many of us would not disagree with. And even some of the criminal law issues will be troubling. But I think we're in for a long haul. Some of these justices are fairly young as Supreme Court justices go, so they can and are likely will be on the bench for a considerable amount of time. And it's a 6-3 majority. It's kind of hard to overcome that. Mm-hmm. But over time, you know, things will turn, but I believe it'll be a long time.
Yeah. And I guess there is the heartening idea, as you said, that not all of these decisions are wholly politicized.
Yeah.
I think like 40% of all decisions are 9-0.
Yeah.
But there are these really important cases
Yeah.
that affect people's lives that are going to be crucial.
Yeah.
And maybe not in a way that many of us would like. And that may be a little bit of a dim way to end things. Would you like to say anything on a hopeful note before we welcome Louis to say goodbye to all of us?
I can do it.
Okay.
I had the privilege to teach with then Judge Ketanji Brown Jackson, and thrilled to see that progress. And I think she's going to do a fantastic job. And I'm trying to come up with diplomatic words here. As a single mom, it's great to see somebody on the Supreme Court bench who is juggling the mom thing and the judging thing. It is not an easy thing. And so I'm glad to see that. As there are other issues, but I'm glad to see that glass ceiling finally get broken. This is the first time there's been a mom of young kids on the Supreme Court. So, baby steps.
Okay, thank you.
Okay.
Many thanks to our distinguished alumni judges and to Professor Breen. It was a great privilege to host this program with you. We are delighted to see so many of our Brandeis alumni and friends coming together to explore topics with our Brandeis faculty and alumni experts, both in person here at Brandeis and online. We look forward to you joining us for an exciting array of programs throughout Alumni Weekend, and we greatly appreciate your participation and your continued support of Brandeis University. Thank you, and thank you.
Thank you.
Thank all of you.
Thank you.